Sounds good.
Bismillah ar-Rahman ar-Rahim. Thank you very much for attending our fifth webinar this cycle from ISABA. Today, I'm happy to introduce our moderator, Dr. Asma Abdel Halim. She's an associate professor with the University of Toledo, Department of Women and Gender Studies. The floor is yours, Dr. Asma. Please go ahead.
Well, thank you. Salam to all of you. And I am sure that you are following a landmark in the history of Sudan today, December 19. It is indeed an important date. It was the day that the country's independence was declared in 1955. Today, 66 years later, we are still fighting for liberty, peace, and justice. Needless to say, the three words are in the heart of human rights, which is our topic of this webinar. Our speaker is none other than Dr. David Phillips, who is currently director of the program on peace building and rights at Columbia University's Institute for the Study of Human Rights. Dr. Phillips has worked as a senior advisor to the United Nations Secretariat and as a foreign affairs expert and senior advisor to the US Department of State. He was the president of the Congressional Human Rights Foundation. In addition, he held several positions that dealt with conflict resolution and peace building. Dr. Phillips' intellectual contributions to the areas of his expertise is massive, to say the least. He authored books such as From Bullets to Ballots, Violent Muslim Movements in Transition, Losing Iraq, Inside the Postwar Reconstruction Fiasco, Unsilencing the Past, Track to Diplomacy and Turkish-Armenian Reconciliation. He has also authored many policy reports, as well as more than 100 articles in leading publications such as the New York Times, Wall Street Journal, Financial Times, International Herald Tribune, and Foreign Affairs. Please welcome Dr. David Phillips to the podium. Thank you.
Dr. Asma, thank you for your generous introduction and your warm welcome. I also want to thank Montasir Abbas, the chair, Nada Fadul, the vice chair, and the Association of Sudanese American Professionals for hosting today's discussion. I also want to acknowledge my friend and advisor, Mufadal, with whom I'm in regular contact about all matters concerning Sudan. So thank you all for having me. Today's webinar comes at a very historic occasion. Not only historic measured in terms of the past, but also historic because we are at the threshold of a new Sudan. Will democracy prevail? Will civilian authorities resume their leading role? These are aspirational goals. We want to make them actual goals, which is why we're meeting and discussing questions surrounding transitional justice. The political agreement of the 21st of November, 2021 is a watershed moment. It represents the beginning of a transitional process, not the end. Looking forward, we must also remember what was lost. While we welcome the reinstatement of civilian leadership, we honor the sacrifices of protesters and their sustained civil disobedience that led to the removal of Omar Al-Bashir on April 11th of 2019, after 30 years in power. We honor those who perished during the June 3rd massacre in Khartoum. We honor the Forces for Freedom and Change, who negotiated a political agreement and a draft constitutional declaration, legally defining a 39-month transition phase to return Sudan to civilian democracy. We know that that transition was interrupted by the recent military coup. However, we're hopeful with the agreement of November that things are back on track. And I want to salute the million Sudanese who were in the streets today in Khartoum and elsewhere around the country. Without civil disobedience and their vigilance, we run the risk of backsliding and a return to tyranny. So we have to keep our eye on the prize and work collaboratively and earnestly to make sure that the Sudanese people can enjoy basic freedoms that they deserve and through their struggle that they have earned. Transitional justice is a term we hear a lot about, and it varies from context to context. In the Sudanese context, it's about returning Sudan to civilian democracy based on the 2019 constitutional document. There are several important steps and challenges that Sudan faces. So transitional justice is not a linear process. It's a process that touches on many different themes and requires different measures in order to consolidate progress. We look for further steps on Sudan's path to civilian rule and democratic self-government. First, the release of all political detainees. Second, the establishment of a committee of investigation to ensure that those responsible for violence against protesters are held accountable. Third, we demand that the government lift the state of emergency. We encourage the early progress towards the formation of a civilian government comprised of independent experts. But as we've seen in the past, this process can derail if civil society as a whole isn't fully committed and on board. When we talk about political transition, we're not talking about an event that occurs on a single date. We're talking about a process that occurs over time. And for this process to be successful in Sudan, it must be inclusive. All components of the 2019 civilian-military partnership should participate in the national dialogue, with civilians taking the lead. Sudan also needs a roadmap towards elections in late 2023 or early 2024. Without a roadmap and specific dates, the risk of backsliding towards tyranny is greater. Transitional justice is needed so the people of Sudan can realize their goal of a democratic, stable, and peaceful nation. And after the many sacrifices of Sudanese civil society, the US and the international community stands in solidarity with the people of Sudan as they pursue their democratic dreams. Transitional justice not only protects the Sudanese from violence, it is also a way to hold the perpetrators of violence accountable and move forward from tyranny to democratic self-rule. There are many questions that arise about the recent events, and we'll see over time the extent to which answers are forthcoming. I'm puzzled as to why the junta accepted the November 21st declaration. Of course, US, UN, and international mediation was critical, but were the generals promised immunity from prosecution? Were they promised that they would be allowed to keep the wealth that was stolen from the Sudanese people? We need answers to those questions so that we know what we're dealing with, what commitments were made, and how we're going to move forward to consolidate progress. The international community has a big role, not only in mediation, but now in monitoring and enforcing the terms of an agreement. The US, of course, is critical, as are other countries like the UK and Norway. We also look to the United Nations Integrated Transition Assistance Mission in Sudan, UNITAMS, to make sure that civil society development and institution building proceeds apace with the political events. After the overthrow of Omar al-Bashir in 2019, many Sudanese were impatient with the lack of immediate progress, establishing a transitional justice strategy and creating transitional justice mechanisms and institutions. As we've seen elsewhere and in Sudan, the longer this takes, the more difficult it becomes. The longer it takes, the greater the risks are of returning tyranny and the will of the people being denied. During Bashir's reign, hundreds of thousands of Sudanese were killed or disappeared in Darfur, Kordofan, Blue Nile, and elsewhere. About 280 persons were killed and about 40 went missing during the uprising in June of 2019. The Transitional Military Council and the Freedom and Justice Forces adopted a transitional document on the 20th of August of 2019. The document extensively addressed transitional justice themes. It also called for the creation of a Transitional Justice Commission to safeguard the way forward. So when we think about enforcing transitional justice, we should be clear on the term, what is meant by the words transitional justice. It's a term used to describe how a society comes to terms with a legacy of human rights abuses and violations of international humanitarian law. Transitional justice helps consolidate political transition from an authoritarian or a dictatorial regime towards democratic government, which protects and promotes human rights, not only in name, but in deed. Transitional justice is critical to achieving sustainable peace, the rule of law, and state building in countries like Sudan that are emerging from violent conflict and authoritarian rule. Transitional justice seeks a balance between accountability and other measures to help heal society. It's a process that acknowledges the dignity of individuals and the suffering of victims. It recognizes violations and provides redress, including reparations. The complementary pillars of transitional justice are: 1, accountability, investigating and prosecuting those responsible for mass crimes. 2, truth-seeking, uncovering and making public the truth about the violations, including their root causes. 3, repairing the lives of victims, providing redress and reparations. And 4, undertaking reforms, consolidating democratic developments, and preventing the recurrence of backsliding. These 4 elements are like the 4 legs of the stool. They work together, they support one another. Without one, we risk the other elements failing to be implemented and backsliding towards tyranny. In a broader conceptual sense, transitional justice is also a tool for conflict resolution and peace building. It establishes a foundation to address the underlying causes of conflict by enshrining the rule of law and institutionalizing political, civil, cultural, and economic rights. Effective transitional justice techniques conform to international legal standards, norms, and obligations. Although the development of a transitional justice strategy always must be based on the unique history and cultural characteristics of the country and the people concerned. We hear a lot about truth in the context of transitional justice. In this regard, we need to recognize that justice can be achieved through juridical mechanisms that try individuals for their crimes in a court of law. However, trials risk becoming politicized as victims turn the tables on the perpetrators. Victims may seek revenge, precipitating or continuing a cycle of violence, especially in countries with weak institutions and a nascent civil society. There are always tensions that exist between accountability enforced through a criminal justice system and non-punitive approaches, which may include truth-telling and amnesty. Some maintain there can be, quote, no peace without justice, while others believe that focusing on justice can be an impediment to peace. Each situation is unique. Each person weighs the balance between peace and justice based on their personal and national experience. This introduces the concept of amnesty. This victims, quite rightfully and understandably, often view amnesty with skepticism. They believe that it condones impunity. Members of the former regime want to avoid punishment. They want to move on, wash their hands of the past. They don't want to be held accountable for what crimes they may have committed. The Rome Statute, which founded the International Criminal Court and entered into force on July 1st of 2002, is a supranational body that rejects amnesties for serious international crimes. Amnesties are often incorporated into peace agreements. However, they can backfire by creating a culture of impunity. Amnesties are a way for society to heal, but healing cannot be put forward at the expense of holding those accountable who committed the most egregious violations. We think of truth and justice as the twin pillars of transitional justice. It's widely held that truth and justice can be mutually reinforcing. A hybrid system can enforce criminal accountability alongside truth-telling, historical commissions, and partial amnesties. There's no cookie-cutter method. Each strategy, each institution has to be adapted to the needs of the society, its unique culture and history. Other contextual factors must also be considered on a case-by-case basis when designing a transitional justice process. Most importantly, victims need a voice. When developing a transitional justice approach, political and civil society actors should be consulted to understand their needs and goals. The strategy and institution should reflect their priorities. Also, victims and vulnerable groups such as minorities, women, youth, and those who have been displaced have special requirements. Transitional justice must be understood and accepted by impacted communities. It's not a top-down process imposed by a government. It needs to be a grassroots process that takes on board the values and the goals of civil society so that the transitional justice strategy and mechanism has buy-in from people in the country as a whole. I want to emphasize the importance of a gender-sensitive approach because violations affect men and women differently. I also want to emphasize youth participation. It's important to build the capacity of young people for active citizenship in post-conflict recovery. So youth also need a voice when designing a transitional justice strategy. The root causes of conflict and the nature of crimes committed by members of the security sector, its proxies, and armed groups affect the design of transitional justice mechanisms. Economic issues as well, such as the loss or deprivation of property, also affect the approach to transitional justice, which can also include reparations, making victims whole for the material and emotional losses they've suffered. Transitional justice isn't a system that's imposed from outside. It works best when it's carried out by local and national actors. Therefore, building national capacity is a priority. National human rights institutions, civil society, including tribal and religious leaders, should directly participate in the design and implementation of transitional justice mechanisms. It's a community-driven process. It's not something that's determined at the UN or by the US government in Washington. It's determined by the directly affected communities themselves. Of course, international assistance and expertise can assist local actors to develop and implement their own transitional justice and rule of law agenda. It should always take into consideration priorities of the directly affected community and the values of people who were victims. It's not something that occurs automatically or quickly. It's a process rather than an event. The transition from tyranny to democratic rule occurs over time. Transitional justice requires patience and flexibility. It must be carefully designed, tailored to the specific context, implemented effectively and inclusively, and agreed upon by all the relevant actors. Otherwise, transitional justice risks renewing conflict. Other risks to transitional justice include exploitation by the government for political ends, reaffirming impunity as a norm in society, the militarization of transitional justice procedures, appearing to grant impunity for military personnel primarily responsible for mass human rights violations. Those who have committed crimes must be exposed through a truth-telling or legal process, and they must be prosecuted with fair rights accorded to the accused. Transitional justice must be transparent to those who are most affected by conflict or the victims of the former regime, especially those who are displaced by the conflict, refugees and IDPs. I mentioned before the importance of reparations programs. Reparations shouldn't stand alone. They should be part of a bigger package. They must be linked to other justice initiatives. Otherwise, they may be seen as a one-time payout for victims, which could create hostility among the society as a whole. Accountability is the primary feature of transitional justice. Persons who have committed mass atrocities typically believe they'll not be held accountable for the crimes they have committed. They have a resulting sense of impunity, which may often contribute to the recurrence of violence. Certainly, it contributes to resentment in society among those who were victimized. Prosecution of the perpetrators is a form of deterrence. It delivers a strong statement against impunity and demonstrates that the new government is willing and able to transition from its violent past. Prosecuting perpetrators sends a signal that criminal acts will not be tolerated in the future. Prosecutions also deter revenge and retaliation, restoring the rule of law in a post-conflict setting. By holding individuals accountable, whole groups are less likely to be blamed, thereby mitigating revenge-taking and advancing the broader goal of national reconciliation upon which sustainable peace must be based. The investigation and prosecution of international crimes is rooted in international human rights and international humanitarian law. This law goes back to the Nuremberg trials after the Second World War. It continues with the establishment of the international criminal tribunals for the former Yugoslavia, ICTY, and for Rwanda, ICTR. The International Criminal Court that was mentioned earlier was established in 2002 as a permanent international court located in The Hague, Netherlands. It has jurisdiction over crimes committed in the territory of a member state of the court, and under the Rome Statute's complementarity principle, the ICC is a court of last resort. Domestic courts bear the obligation to deliver justice. However, when domestic courts are unwilling or unable to deliver justice, then we look to the ICC or other international mechanisms. We also look at hybrid mechanisms that involve international expertise joining with national figures to enforce the rule of law. First and foremost, we look to national courts that may hold human rights perpetrators accountable. If the crimes are codified in national law, then national courts take the lead. Human rights prosecutions work best when there's a capable and credible judiciary that can conduct impartial and independent trials. Transitional justice should seek to strengthen national institutions of justice and security, not to replace them. National legislation having bearing on transitional justice should conform with international human rights law and international criminal law. In many post-conflict countries, however, local court systems are not capable of handling the scope and complexity of prosecutions for mass atrocities. In some countries, we've seen how those local courts have even helped perpetrate crimes themselves. It's important to build local capacity. Local lawyers and judges may receive assistance from international counterparts to support the work of hybrid courts. There are a number of hybrid courts that we can look to as examples in international law. For example, Special Panel of Serious Crimes in Timor-Leste, the Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, the War Crimes Chamber in Bosnia and Herzegovina, and the Special Tribunal for Lebanon. What are the characteristics of hybrid courts? They are temporary by design, do not exist in perpetuity. They include local and international staff working side by side. Local personnel are not subordinated to international experts. And these hybrid courts apply a combination of national and international law in order to be most effective. The level of international involvement is determined by domestic leaders who regulate the role of international actors. It's not a role that the international actors themselves can stipulate. They have to be invited to participate. Their mandate has to be made clear by the local actors. And then there needs to be a system for local and international actors to work together in cooperation side by side. We also think about national administration, particularly in the Sudanese context. A grassroots or a bottom-up approach to transitional justice should be considered as part of the national transitional justice agenda. It adopts traditional mechanisms of truth-telling, dispute settlement, and symbolic retribution that adhere to both local customs and international legal standards. The people of Sudan have evolved over many decades their own approach to transitional justice, which reflects their history and their culture. For example, an example of the national administration can be found in Galad, or embrace, which is practiced in the East. Gudia, meaning mediation and reconciliation, is practiced in Darfur. Ajawid is another model. On my last trip to Sudan, I had the blessing of meeting Sheikh Ali Ayagut, a community leader and teacher whose juridical and conflict resolution authority is a birthright passed down over 900 years. That historical experience needs to be respected. Rwanda developed the Gacaca courts as an effective grassroots justice initiative. The Gacaca courts were a network of 12,000 community-based courts that tried the perpetrators of genocide and sought their acknowledgement of guilt. It emphasized forgiveness by victims and reconciliation between communities. These courts tried more than 1 million people implicated in Rwanda's genocide. The Gacaca courts helped prevent the cycle of violence and limited the potential for disputes to escalate. Of course, accountability needs to be at the core. Under international criminal law, major crimes amounting to gross human rights violations include genocide, which is the killing, forcibly transferring of children or causing serious bodily or mental harm. The perpetrator knew that his or her actions would result in more than one death and had the requisite intent to destroy in whole or in part a national, ethnic, racial, or religious group. This question of intent is critical. Genocide doesn't happen by accident. It's typically something which is planned, premeditated, and carried out by an authority. Crimes against humanity are acts that are committed as part of a widespread or systematic attack against the civilian population, including but not limited to murder, imprisonment, torture, rape, sexual slavery, and enforced disappearance. War crimes are acts that are committed during an armed conflict that violates international humanitarian law, including but not limited to murder, mutilation, inhuman treatment, torture, rape, and slavery. It's important that we have a definition of crimes for which we will seek some kind of retribution or develop mechanisms to hold the perpetrators accountable. These crimes that I've just defined can be prosecuted in international, hybrid, or national courts that have jurisdiction. Prosecution must abide by clearly established procedures, including the basic due process conditions enshrined in the International Covenant on Civil and Political Rights, the ICCPR. Trials help address the impunity gap. Frequently, the perpetrators of atrocities become part of a new government and will be reluctant to promote prosecutions that may end up punishing themselves or members of their group. Amnesty is a controversial topic. On the positive side, it can help promote reconciliation in post-conflict transition societies. Amnesty proponents believe that trials are politically untenable, that they're likely to undermine new democracies and perpetuate conflict during the period of political transition. Amnesties, however, are a two-edged sword. They can undermine progress, they can fuel resentment, and if the perpetrators aren't held accountable, there can be acts of reprisal against them that can destabilize the society and return the society to a condition of widespread violence. Let's talk for a moment about truth-telling. The right to truth is recognized by several international, regional, and domestic institutions. It's also recognized under international law, both as an individual and collective right. The UN General Assembly has passed resolutions on the right to truth. Exercising the right to truth can help prevent the recurrence of violent crimes. Society can break the cycle of violence by confronting the truth, determining who was responsible for the crimes, assessing the impact on victims, and understanding the root causes of violence. The state is obligated to uphold the right to truth. It cannot be party to an obfuscation process that seeks to bury the truth and provide forgiveness to the perpetrators of violent crimes. The state also has a duty to preserve collective memory and prevent revisionist history and denial. Victims and their families have the right to know the truth about conditions in which violations occurred. In the event of a death or disappearance, there's a right to know the victim's fate and to have access to their mortal remains. States are obligated to uphold the right to truth because authoritarian regimes may try to rewrite history and deny atrocities in an effort to preserve their positions, their powers, and their privileges. Truth-telling initiatives can be official or unofficial. Official truth-seeking efforts include Truth and Reconciliation Commissions, TRCs, commissions of inquiry, fact-finding missions, criminal investigations, historical commissions, and investigations that are conducted by national human rights commissions. So there are many different mechanisms and platforms through which we can gain an understanding of the truth. Effective truth initiatives help reinforce other measures, such as prosecutions, reparations, and institutional reform. For example, truth-telling has both directly supported prosecution in countries like Argentina and Chile. There's also been an alternative to prosecutions in South Africa, where admitting the scope and nature of one's crime is the basis for getting off the hook, so there is no prosecution. Truth-telling is also related to what I'll call memory initiatives. These involve memorials, museums, and commemorative activities. Once the truth is established, it can be enshrined. In fact, it must be enshrined so that we remember. Truth commissions, which is the most widely used vehicle for investigating and getting to the truth, serve as a way for society to explore what abuses occurred, why they occurred, and how to prevent their recurrence. The design and development of truth commissions should be based on extensive consultations with the public. It's not something that's defined behind closed doors. It needs to be transparent. Persons appointed as truth commissioners should be persons of integrity who are independent of the parties to the conflict or the perpetrators of abuse. These qualifications are critical for the process to have integrity. Truth commissions are characterized by 4 principles. They focus on the past, they portray the pattern of human rights abuses, they exist for a temporary, predetermined period of time, and they're vested with authority to access information. They're typically established for a specific period of time in their founding charter. Most truth commissions are given 6 to 9 months to finish the investigation and then submit a report, which is usually a public document. Truth commissions vary in size, budget, goals, aspirations, and mandate. Some truth commissions have reconciliation in their titles, others do not. Oftentimes, revealing the truth can lead to national reconciliation. It can also be a spark that contributes to more and continued conflict in the society. A related feature to this work is reparations. Financial reparations serve as an acknowledgement of past wrongs by the state, while enabling effective measures to repair the lives of victims and their families. The final report of a truth commission may recommend reparations. Reparations can be material or they can be symbolic. The UN General Assembly reaffirmed the right of victims to reparations in the basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of human rights law. Although reparations frequently involve monetary compensation, there are several forms of reparations. They can be material, or as previously mentioned, they can be symbolic. They can be individual, or they can be collective. Material reparations include payments, pensions, free healthcare, scholarships, skills training, return of property, and microfinance loans. Symbolic reparations demonstrate public acknowledgement and may include memorials, the renaming of public spaces, apologies by the state and the perpetrators, and designating days of remembrance. Individual reparations acknowledge the harm done to individual victims and provide them with concrete social and economic benefits. Collective reparations are benefits provided to people comprising a group, a community, or representing a region. So this process of transitional justice isn't focused only on crimes. It also is the gateway. It's a portal for broader institutional reform. Institutional reform encompasses a range of measures to consolidate democratic progress. It may include constitutional amendments or adopting international human rights conventions. In countries that are emerging from violent conflict, reform focuses on the security sector, the armed forces, law enforcement, and the intelligence agency. Security sector reform, or SSR, aims to create effective and rights-respecting security and justice institutions in the government that are controlled by civilians and operate in accordance with human rights standards and abide by democratic governance. SSR requires vetting members of the security and justice sectors and also removing from office those responsible for violating human rights violations in the past. It's not about turning a blind eye. SSR means studying, exposing, and holding accountable security sector personnel that have committed atrocities and crimes. This can involve disbanding military, police, or other security structures. It can involve removing any personnel from security or governance apparatus. They must abide by the due process of law and the principle of non-discrimination. Usually hand in hand with SSR is something called DDR, disarmament, demobilization, and reintegration. DDR usually involves armed groups, and they are linked, SSR and DDR. It seeks to remove weapons from combatants. This is the disarmament. Remove combatants from military structures, the demobilization, and help former combatants integrate socially and economically into society. This is reintegration. DDR is often established through a peace agreement. It supports ex-combatants so they can become stakeholders in the peace, and also economic stakeholders in society. When we think about institutional reform, we have to fully consider ways of addressing inequalities. Addressing inequalities provides the foundation for creating a new society based on principles of freedom and equality. Enshrining individual rights through statute or through a constitution is the most effective way to address inequalities. In countries that are emerging from ethnic or sectarian conflict, special measures to protect and promote group and minority rights may be necessary. Economic inequalities may encompass disparities in the access to and ownership of assets, such as possession and access to land, livestock, human capital, and communal resources such as water, minerals, and public infrastructure. Economic inequalities may also concern access to services such as education, healthcare, potable water, housing, and jobs. So in order to institutionalize these strategies, oftentimes countries considered the establishment of a Transitional Justice Commission. And Sudan itself has also talked about establishing TJC. The Transitional Justice Commission aims to help states transition from war to peace or from authoritarian rule to democracy. It addresses legacies of human rights abuse. It can involve redress, seeking to prevent the recurrence of violent conflict, and assistance so that the state and society can heal. To summarize, transitional justice is a concept. It requires leadership as well as participation by the society as a whole. It also has to be institutionalized and codified in law or through the establishment of indigenous bodies such as the Transitional Justice Commission to carry the work forward. In Sudan in particular, the period leading up to 2019 was a period of trauma for many in the country as a whole. The subsequent events in June, the crackdown against protesters, underscore the importance and centrality of transitional justice presently and going forward. Transitional justice is not a concept or an idea. It's a set of institutions and commitments entered into by both the governed and the governors, so that there's a partnership in society to hold perpetrators accountable, create conditions for sustainable peace, and allow Sudan to move forward. Columbia University has worked with the Darfur Bar Association and other bar associations and NGOs in Sudan in order to popularize these ideas. We pledge our continued commitment to transitional justice efforts with local partners, which is why when I received the invitation from the Association of Sudanese American Professionals, I was so pleased to accept the invitation to discuss this critical area of work and to develop networks of like-minded colleagues with whom Columbia can collaborate in the future. Our partnerships involve Sudanese in Sudan as well as Sudanese diaspora. Either way, we pledge to you our cooperation, our solidarity, and support. Thank you for asking me to present this morning. I may have spoken too long, but I'm pleased to answer any questions. So, shukran.
You are muted, Asma.
Shukran to you, Dr. Phillips, and thank you so much for such a rich and detailed presentation. And I'm sure that most of what you have said today is going to be a matter of discussion between all the people. And my phone beeped several times, so I clicked on it and people are surrounding the palace, the People's Palace. So I don't know, I certainly hope it is going to be an end of something, not beginning of more violence. And here I open it for questions from all those present. And we have about 15 minutes, 15 to 20 minutes for questions and answers. Please put your question in the Q&A.
Let me just add a point, since you talked about people surrounding the palace. Of course, violence is always a last resort. We don't want people to have to fight for their rights. But when their rights are denied and there's no legal or institutional recourse, then people often stand up and demand their rights, and they have to struggle for them. Oftentimes without struggle, there's no gain. So I want to express my solidarity with those who are protesting in Khartoum, urge them to enter into negotiations, and to let them know that the international community stands in solidarity with their efforts. I'd be pleased to answer yours or other people's questions.
Well, thank you for this statement of solidarity. It's most needed in such occasions. So if you would like to put your questions there.
So Dr. Asma, I will start. I raise my hand and Bakri also raised their hand. Since we are co-hosts, we cannot type questions in the Q&A. That's a part of the disbenefit of being the co-host. Thank you very much, Dr. Phillips. My question is related to the transitional justice processes that we have observed in different nations. And I wanted to get your opinion about what we have learned, the lessons learned from what actually worked quickly and what took a while to materialize from what we have seen in the past around the globe.
There's a balance between accountability, which is a juridical process, and forgiveness, where people divulge their role in a crime. And as was evidenced in South Africa, they're forgiven by the state apparatus. I think that balance is important, but we shouldn't tilt too far in one direction or the other. People need accountability. If there's no accountability, then whole groups or the society as a whole are blamed for the crimes. So we need accountability, but we also have to recognize that witch hunts can occur where groups are held accountable and where citizens and civil society take matters into their own hands. So that balance needs to be determined based on the history and culture and the preferences of society as a whole. We shouldn't tilt too far in one direction or the other. My initial instinct is that with no justice, there's no peace. So people need to be held accountable. But we don't want to enter into an open-ended process where perpetrators are prosecuted. We need to move on so that society can heal. Soon these people will find the right balance in consultation with one another.
Thank you very much.
Thank you, Ms. Phillips.
Okay, I have a question about, most of the time we see the culprits leaving the country. In the combination of national and international, could the national move to where the culprits have fled to and hold that truth or whatever transitional justice, or just bring them to courts of where they fled to?
So recently, we've seen the principle of universal jurisdiction exercised in a German court. An ISIS member committed crimes against a young woman in Fallujah. The ISIS member wasn't from Germany, the victim wasn't from Germany, but the perpetrator was arrested in Greece, extradited to Germany, and there was a court proceeding there. So what's important is that if people commit heinous crimes, they just don't take their money and go live in a palace somewhere and feel as though they have immunity. There is universal jurisdiction, and they should know that judges in Europe, in Spain, or other countries will hold them accountable, that Interpol will arrest them. If they have committed a gross human rights violation, they don't walk away scot-free. There are mechanisms outside of national courts to hold them accountable so that there is no impunity. That's why we need the right balance between national courts and international and hybrid courts so that perpetrators don't get to walk away scot-free, but know that they will pay a price for their crime.
Thank you. I see Bakri raising his hand.
Yes, thank you very much. Dr. David, for a very informative webinar. I just want to ask you, we have really seen very good initiatives and a lot of knowledge in the Darfur lawyers. They have a group, I think, Darfur Lawyers Association. Very knowledgeable, very measured, very professional, and I hope
You got muted, so if you want to continue, unmute yourself.
Oh, sorry. I say thank you for an informative presentation. We have seen a lot of progress in Darfur. There is a group called the Darfur Lawyers Association. They have come up with very professional initiatives and so on. And I'm sure your center has to do with, has something to do with that. So my question is, could you talk briefly about your experience working in Darfur? What were the successes? What were the drawbacks? And could this be repeated in other areas of Sudan? The Nuba Mountains, even the center in Khartoum right now. There is violations of human rights. Could these efforts continue from the center as you mentioned?
Thank you for that question, and thank you for also mentioning the Darfur Bar Association.
Yes.
We work very closely with Mr. Sadig. He does exemplary good work. It's important that there be a meeting of the minds, a coming together between state initiatives like the one we see in Darfur and national initiatives coming out of Khartoum. That's why the consultation that we've seen between DBA and Prime Minister Hamdok sets an important precedent for harmonizing local and national initiatives. We would hope that other states where people have been victimized would develop their own capacity to do that, that they would reach out to the national government, develop partnerships. And since Columbia University has developed a roadmap for establishing transitional justice institutions, and we'd be pleased to share our experience working with the Darfur Bar Association, with other bar associations, and also other civil society leaders. For example, we've had extensive contact with some of the universities in other Darfur states, and we're pleased to share whatever knowledge we have, pleased to be a bridge whereby different organizations within Sudan can share experience with one another. What we need is to have local initiatives. There's an expression that says, think globally, act locally. So we've studied global international humanitarian law, and we've sought to cultivate local partners so they themselves can carry this work forward. Columbia is pleased to share its experience with any Sudanese partner who wants to move forward on the transitional justice front.
Okay, I would like to ask another question. It's my legal background always jumps to me. So is there a mechanism to revoke the promise to absolve anyone of liability if they started to lie, or if they brought in things that were not needed, try to get them around what she was supposed to do? Is there a mechanism to effectively revoke the total absolvement of liability for that person?
If there's a Truth and Reconciliation Commission and the perpetrator comes forward and discloses his or her role in committing crimes, typically the statute that founded the TRC will absolve that person of guilt and responsibility. If that person is lying, if they're dissembling, then whatever protections they are afforded through the TRC's founding charter should also be withdrawn. If people play by the rules, they can benefit by those rules. If they want to obscure the truth rather than highlight what actually happened, then their protection should be withdrawn and they should pay a penalty through a legal and juridical process.
Okay, some questions actually went to the chat instead of the, from Iman Zain Al-Abdin. In the context of Sudan, what do you think are the prospects of getting people, especially those personally affected by terrible atrocities, to shift conceptually and psychologically from a punitive idea of justice to a more constructive one in which their sacrifices are understood and valued as the basis for building a new Sudan? In light of other countries' experiences, what practical steps would be most effective to achieve this shift? Long question.
That's a long question and a good question. If civil society is involved in the design of a truth-telling process, it will have input into whether or not the focus is on forgiveness or on accountability. Different societies have shown preferences based on the current conditions and their past history. So it would be useful to study how other countries have undertaken a truth and/or reconciliation process, what the balance is between commissions of inquiry and TRCs. What's important here is dialogue. If we're going to build a new Sudan, it has to be based on transparency and cooperation. If the Sudanese people are committed to transparency and cooperation, then the authorities themselves must also show the same commitment. That's the only way that a society can heal and move forward. There needs to be transparency and dialogue so that the suffering of people is known, and so the perpetrators can be held accountable should their crimes rise to such an egregious level that they should be punished.
Okay, thank you. There is a last question if you have time to take it, because I know you have some time constraints.
Sure, what's the question?
Okay, first there is a thank you for a great perspective and look at the big picture. What are, in your view, the most effective actions by activists like our group to influence the US and EU policies?
It's important to shed light on what happened. For there to be cases that are prepared, documentation compiled. In the United States, the US Congress has adopted the Global Magnitsky Act. This is a legislation that allows persons who are corrupt or who have committed mass human rights abuses to be sanctioned so that their travel is limited, so that their assets may be frozen. All that starts with documentation. For each individual case of abuse, we should gather information on what was the nature of the crime, who was the victim, what kinds of documentation in the form of video or audio testimonies exist. Transparency is critical to accountability. So we have to work together to create transparency and then bring the findings of those inquiries to policymakers in the Congress, in the US Congress, or in the international media, so that those perpetrators don't walk around in freedom so that they know that there's a price to pay, and that at any moment, either the US government or another government can hold them accountable for what they did. There's no impunity when it comes to gross human rights violations. People have to take responsibility, and they should be punished in accordance with national laws or the terms of the truth-telling process.
Okay, thank you so much, Dr. Phillips, for your answers, and thanks to you all. I think we have enjoyed the rich information from Dr. Phillips, and it is going to be the most watched recording for this group. Thank you so much. And with this, we wrap up this webinar and see you later in some other webinars. Thank you.
Let me just convey my respect to Sudanese friends, my appreciation to you and the hosts of the session today. It's an honor for me to discuss these matters at this critical moment in Sudan's history.
Thank you very much, Dr. Phillips. On behalf of all the Sudanese American professors in America, I extend my thanks and respect to you. This is very beneficial. Also, thank you very much, Dr. Asma Abdel Halim, for the very nice moderation, very effective moderation. We will be in touch with you, Dr. Phillips, and thank you very much.
Okay, thank you. Shukran.
Shukran.
Okay, bye.